What next, Mr.
Yes. Lord,
One aspect also can be kept in mind, that is the referring order in the last paragraph refers the whole matter to your lordships. It says 120, we refer the whole matter.
We'll just look at that.
Your lordship.
Same time, whether the appeal had been filed by the union of India. Yes, the ALIGARH was.
yes, my learned friend is right, factual. And thereafter, Government of India, on a considered decision, filed an affidavit saying that we are not pressing this appeal. And we are supporting, when you say the full truth,
And
not half
so
truth.
technically on paper, it remains the appeal.
It remains,
Subject,
appeal
of course,
remains.
your appeal that
I have
you
not
want to
been
pass.
permitted to withdraw the appeal, but it is the stand of Union of India that judgment of the division bench is true.
And there's an appeal by AMU also.
Yes.
Separate appeal.
Several, there are several.
Solicitor General, in case we go into 81 amendment, then this issue will arise. Whether a legislative act or an amendment made by the parliament, subsequently you can withdraw. That will be an issue.
Correct, Malad. Correct. And I'll have to address that, Malad.
Therefore-
I am not running
therefore-
away from that question.
Correct. And there are two options before us. Either we accept the ratio in Bhasha. In case the ratio in Bhasha is accepted, then we come to three conclusions. It's de jure established by a statute and not by the minority committee. It is de facto established not by the minority committee. Three, it is not administered by the minority committee.
And four,
And-
surrendering.
Surrendering is part of 1, 2, and
First
3.
one, yes.
1, 2, and 3.
A lot of people subsumed that.
It's subsumed in that.
Yes.
It's an argument dealing in support of that. Now, as far as 1981 amendment is concerned, it only deals with de jure, first part of it, de jure establishment of the bias statute. It doesn't deal with the other two. 81 amendment does not touch. And if I'm not mistaken, when we read Bhasha, it deals with all the three contentions.
Correct.
I think you're also of the opinion it deals with all the three situations.
Yes.
De jure, de facto, and administer.
Correct. Your Lordship, sir. My Lord, now,
If Aziz Bhasha is declared to be right by your lordships, then we would have to take recourse in 81. That's separate issue.
that's the whole point.
That is something, what is the effect of 81 amendment? That may have to be sent back to the High Court itself for fresh consideration.
No. It will be before a regular.
Decided here.
That will be a separate, let's not open up a new
That's
debate.
quite right, Lord. Quite right.
Lord, the position will be this, and I leave it at that. I leave it at that. Lord, the position will be like this. If they succeed, they get a second chance before a regular bench. If we succeed, then there is no chance. If they lose, I'm sorry, reverse. If they lose, they get a second chance. If we lose, we lose.
No, Mr. Mehta probably be a very limited chance.
Lord, your Lordship knows the ingenuity, my Lord. This is pending since years.
Because if we uphold on the second and third principles, even if they succeed on the first part, that statutory establishment has been taken away.
Lord, on that, we have sufficiently assisted your Lordships, whether to take it up here or wait. It is entirely your Lordship's
We'll
call.
just take it
I'll
forward.
not.
We'll also like to read Bhasha with you, and then I think we
But
can
before
pick up
that,
again.
Lord, what I have done is, Lord, I desire to read the entire debate of 65, amendment of 1965. But with a view, my Lord, not to curtail, my Lord, with a view to curtail my time, my Lord, I will read only one, where the Honorable Education Minister, Justice Chagla, my Lord, summarizes. Justice Chagla was, my Lord, dealing with my Lord, member of Parliament called Frank Anthony, who had appeared in Kerala education.
He was a member of our bar.
Yes.
Yes,
Very
he was.
Outstanding.
vibrant member of our bar.
Yes. He was a. There are some
As a
interesting.
young lawyer, I've heard Mr. Anthony argue, actually, Frank Anthony argue.
Lord,
The school is named after him. The Frank Anthony
yes.
Bar.
Lord, he was
Yeah, he established
a
it.
nominated member as an Anglo-Indian committee. he was a nominated member as an Anglo-Indian community. My lord, in fact, there is a very beautiful and interesting exchange between Justice Chagla and Frank Anthony, my lord, because both were, my lord, were from the same field. But the Justice Chagla had to say that you will have to concede that I know a little law, including the constitutional law. That's what Justice Chagla said in the debate, my lord. And, Lord,
All right, let's see, what are we seeing next now?
my lord, please come to, my lord, my note 2B. My lord, I am reading only one paragraph of Justice Chagla's, my lord, address,
This is the parliamentary debate.
parliamentary debate in 65 amendment, when the 65th amendment was introduced. This is inter alia what he said. My lord, what he does is,
Mr. Solicitor, page.
I'm sorry, my lord, page 111 at the foot. But Justice Chagla narrates the history. Justice Chagla does two things. He narrates the history, which I have broadly pointed out to your lordships. And second, he says that there is a reason why our constitution makers have given them a separate status in the constitution itself as institution of national character. And thereafter, my lord, he says this, Lord, at the foot, 2nd September 1965. Your lordships would recall.
Can I request you, by chance, I opened up a wrong page.
2B.
I'm 2B. That's a speech of Monana
Maulana
Azad.
That's right.
Can you just read that also?
The 2B, my lord?
It's 2B, triple
Right,
one.
111 is the,
Can you
No,
just read
page,
that?
your lordships open.
Triple one.
Triple one. I agree. Yes. Maulana Azad, my lords, that is 51 speech.
Yes, yes.
My lord, I wanted to read that, but I was curtailing myself. My lord,
Let's see.
if your lordship, my lord, permits. As far as our constitution is concerned, honorable members are aware that Article 28(3) lays down that religious instruction cannot be made compulsory in any government institution. This necessitated a reconsideration of the question as far as these two universities are concerned. In both the universities, the Hindu university and the Muslim university, the religious instruction is compulsory. This was against the Article